Okay, so today we're going to talk about DUI cases specifically in Wayne County. And I wrote a book called the 313 DUI Defense, Wayne County Drunk Driving Defense. So this book covers just drunk driving cases in Wayne County. So let's kind of go through. We're going to do a slideshow here. So first, who am I? As you can see here, I'm a former prosecutor in New York City, worked in Oakland County as a prosecutor, went to the University of Michigan for law school, dad of 2 young kids, hockey coach, and an author. This book is one of my 9 books that I've written on criminal defense in Michigan. A lot of those books dealing with drunk driving cases, all of them dealing with a proactive approach to criminal defense. So what will we cover in this video here? First, we're going to go through all the Wayne County courts, the judges, the timeline of a criminal case, the art of DUI defense, the 3 different windows we look at for a drunk driving case. At the end of the case, will it be deal or no deal? Are we going to wrap your case up, resolve it, or are we contesting something at trial? And the possibility of an implied consent issue in your case. So here's a list of all the 3rd Circuit Court judges. There's a lot of judges here. Wayne County is a big county. These are all the different circuit court judges. Not all of them currently handle criminal cases, but all of them are capable if assigned to that unit. Typically with a drunk driving case, a felony will be a case that will go down to circuit court. The circuit court will have an arraignment. It'll then go into a different courtroom for potential resolution, ultimately to a trial court judge. And if your case does go to trial, which judge will be on your case? Most drunk driving cases in Michigan, if they're a felony, a lot of them get resolved ahead of a trial, but there's a lot of different judges that will touch your case. And as we talk about being proactive, why it's important to know your judge. Here we have the different district courts, 21 different courts in Wayne County. If you're watching this video, you probably have a good idea of what court your case is going to be in. We have 16th District Court in Livonia all the way down to the 36th Court in Detroit and all the Grosse Pointe courts. So if you're charged with a drunk driving case and you're going to reach out to me after this video, definitely indicate which court your case is at, because it's going to make a big difference. And here's where it makes a difference. So here are all the judges at district court level for Wayne County. Most courts in Wayne County have 1 judge, some have 2 judges, some have 3 judges. So if you're in a court such as Woodhaven Court or a 35th Court, there's 3 different judges, but if you're in, say, Southgate, there's 1 judge. So it's important to know who your judge is. It's important to know their personalities, what they're looking for. And I don't have all the prosecutors up here, but it's definitely important to know who your prosecutor is for your case. Here's the timeline of a criminal case in Michigan. First, you have some sort of interaction with a police officer for a drunk driving case. A lot of times they observe your driving, or they take a statement of an eyewitness that witnessed you driving a vehicle, or they report to the scene of an accident and make observations at that point. Police officers will sometimes issue you a ticket with the charge on that, but a lot of times that the evidence will go to the prosecutor, who's in the middle here, who will examine it and make a determination on the charge itself. For a drunk driving case, we're looking at, is it impaired driving? Is it zero tolerance? Regular OWI? Super drunk? Is it a felony? Do you have prior drunk driving cases? If that's the case, a second offense or a third offense could be charged. As a former prosecutor, I was in this role for many years. The police officer would provide me what the evidence was. I'd examine that, make a determination on what the charge was, and ultimately the police officer then goes to the courthouse and swears to a warrant and says, John Smith on this date was observed operating a vehicle in this city, and a chemical test of this number. I ask for a warrant to have charges formally brought against this person, and ultimately it'll go to a judge who will sign off on that warrant. Next, we have the art of proactive defense. I'm not going to get too into this because I have a whole book on it on the bottom right of the screen here, but ultimately this means once you're arrested for a drunk driving offense, what can you do? What's in your power to impact your case in a positive way? What can we learn from the arrest, the release, and the tracking of your case? How can we put you in the best position going forward to build a solid foundation in terms of creating leverage with the prosecutor and with the judge? So what can we learn from your arrest? What do you recall about your arrest? What is your side of the story? What do we need to know? The release is, what are your bond conditions? Can you leave the state? Can you drive a car? When's your next court date? What are your expectations from the courthouse when you return? What are they looking for? The tracking part is, do you have an active warrant? Is the case in review? Is the blood being tested at Michigan State Police? The police prosecutor in court, they're working on your case. And most people kind of sit back and say, well, I'm going to have court on this date. I'll just show up and figure things out. That's not the right approach to a drunk driving case in Michigan. It's in your benefit to be an active participant in improving your case. And by working with an attorney that's tracking your case and being proactive, that's how we give you the best foundation moving forward in dealing with the prosecutor and the judge. The 3 windows of review. So in Wayne County, the first thing we look at, did the officer have reasonable suspicion to arrest you? Your first contact with the police officer. In order to pull you over or to keep you on the side of the road for questioning, they need some sort of reasonable suspicion that some sort of traffic code was violated, that you committed a crime. They need a reason. And it just needs to be a suspicion. It's a very low threshold for a police officer to be able to have additional interactions with you. The basis of the arrest, probable cause to arrest. Now, a police officer can arrest you even without probable cause. But if they do that and there's merit for filing a motion, it's possible that the arrest itself could be challenged and any evidence gathered beyond that arrest could be thrown out. So, for instance, if a police officer didn't have a good PBT, field sobriety test, you actually passed them. In the video, you appeared to be sober. There was no indication you were intoxicated or impaired. The police officer has you maybe going speeding, which is not an indicator of impaired driving alone. If those factors are in play, but the officer says, you know what, I think this guy or this girl, they're drunk, that's not enough necessarily to arrest you. There needs to be a basis for that, a probability that you actually committed that offense. So certainly something we want to look at in terms of reviewing that. The next thing is the elements of the crime. If after we see points 1 and 2, okay, the officer had a reason to pull me over, okay, officer had a reason to arrest me, what are the elements of the crime? Do I have defenses? And in a drunk driving case, what we're looking for, were you driving a vehicle, or can the prosecutor prove you were driving a vehicle? And number 2, is there some sort of indication of impairment or intoxication in order to proceed on the elements of the offense? Most drunk driving cases, I'd say 98%, are going to have some sort of observation of you driving from a police officer, or you being in a traffic accident and there's no indication that there was another driver, or you just admit, hey, I was driving, I crashed my car. If we have that, well, the element of driving the car is there, and 99% of cases have that element. But there are certain cases where maybe you're pulled over on the side of the road, legally parked in your car, more than one driver, you're outside your vehicle, and you don't necessarily say that you were driving a vehicle. It becomes a little more difficult for a prosecutor to prove that. A second part being the chemical test. Does the prosecutor have a blood test or a data master test that they can bring against you at trial to indicate that in some way you had impairment or intoxication above a legal limit? Those are the elements of the crime that we're looking for. Finally, you're going to say, deal or no deal. We get to the end of the case. We've created goals. We want to reach those goals. How do we make a determination of the best outcome for your case? So here's a list of things we consider. The traffic stop, the accident, driving, field sobriety test, any statements, officer observations, and knowledge and chemical tests. The top part is more, can they proceed against you? Back to those 3 windows: reasonable suspicion, probable cause, and elements of the offense. How strong is the prosecutor's case? When I was a prosecutor and I open up a file and see a police report, I'd say, well, this is an easy one. Prosecute this girl or gal, pretty easy. Or there's some cases where there's issues with the case. How strong is that case? And as a former prosecutor, it's usually a pretty sudden observation. This is an easy case to prosecute. This could be a little more difficult. So I do the same thing for my clients now, looking at the case. What category does that fit into? We also need to consider prior record of the client. Well, is this a second offense, a third offense? what's in their history that we need to worry about with a judge potentially sentencing the client. We need to look at driving record as well. What's going to be the impact on their driver's license? Is this outcome going to be something that the client moving forward can fit within their goals in life? We want the outcome to be manageable. We want the outcome to hopefully be without risk, and we want the client to be comfortable with where they're going with the case. So factoring all this in, what is the best outcome for the client? Is there a deal to be made based upon our proactive leverage at the beginning of the case that we've worked into the prosecutor and the judge? What is the outcome that we've created going to be? If that outcome is not something the client can move forward with, well, then we may need to litigate the case at a trial. Well, what are the downsides of various outcomes at trial? So, deal or no deal. Do we want to move forward with something we've worked out, or do we want to challenge the case? Now, finally, the implied consent. Not a factor in a lot of cases, but if you refused a blood test or a data master test, very important to let your attorney know immediately. Because if you don't, you can lose your driver's license for a full year with 6 points in your license, no matter what happens in your criminal case. So reach out to me if you have an implied consent issue, if you have refusal paperwork, if you remember, hey, I don't think I took the test, they got a warrant for my blood, let me know or let an attorney know. This is very important. So if you're charged with a crime in Wayne County, a drug driving offense, or you know someone who is and you're watching this video, I'd be happy to talk about options and get more into your case.